Welcome to the webinar on Global Perspectives on BITs and FTAs, jointly organized by the Very Young Arbitration Practitioner chapters of Singapore and London, as well as Latin American Practitioners EU. My name is Sunita Advani, and I'm an arbitral assistant to Mr. Michael Lee, an English arbitrator member of 20 Essex. I'm also the founder and chair of Singapore Very Young Arbitration Practitioners, also known as SG-VYAP or SG-VYAP. SG-VYAP and London VYAP are part of the global VYAP network, consisting of national chapters in over 25 countries across 6 continents. We are run by and for junior lawyers and organize events and initiatives aimed at progressing the careers of junior international arbitration lawyers. I would now like to introduce our stellar speakers and fellow expert co-moderator. Our first panelist is Mark McNeill, who heads Quinn Emanuel's international arbitration practice in New York. For over 2 decades, he has acted as advocate in numerous high-value, complex commercial and investment treaty arbitrations under the auspices of all the major arbitration institutions and rules. He also sits as an arbitrator and serves as an expert witness on international arbitration issues. Our second panelist is Sudhanshu Roy, who is an associate in the International Litigation and Arbitration Practice at Foley Hoag in Washington, D.C. His practice focuses on investor-state and international commercial arbitration, as well as arbitration-related litigation before the U.S. courts. Our third panelist is Kexian or Kex, who is a state counsel at the International Affairs Division of the Attorney General's Chambers of the Republic of Singapore. She advises the Singapore government on all matters of public international law, including trade and investment, the environment, human rights, and international organizations. Our fourth panelist is Clara Reichenbach, who is a senior legal advisor with the UK's Department for Business and Trade, where she assists the UK government in drafting and negotiating free trade agreements and bilateral investment treaties. Our fifth panelist is Alejandro Rebollo Ornelas, Director at the Office of the General Counsel for International Trade at Mexico's Ministry of Economy. In this role, he represents Mexico in several investment arbitrations and trade disputes, and is an integral member of Mexico's negotiating team for various free trade agreements and bilateral investment treaties. My fellow co-moderator is Gianni Pizzatola, who is an associate at King & Spalding in New York City and a current Young ICA regional representative. His practice focuses on engineering and construction disputes, advising clients across industries in both arbitration and litigation. Please note that there will be an audience Q&A round at the end of the panel discussion. You may submit your questions for the panelists via the Q&A function on Zoom. Before we begin, we would like to say a special thank you to our technology partner, Maxwell Chambers.
Great. Thanks very much, Sunita. I'll get us started. Thank you everyone for being here, for our panelists, Sunita, to you, and to everyone tuning in online. So our first question, could you please explain what BITs and FTAs are, and what are the current global trends and developments in relation to both BITs and FTAs? Clara, we'll kick it off with you.
Sure, sounds great. Just checking you can hear me all right? Amazing. So let's start with BITs and let's do some context setting. So we're roughly in the 1960s. There have been a number of significant economic and political upheavals at the turn of the 20th century, including several large-scale expropriations of foreign-owned property. So governments are looking for stronger legal protections for the property and interests of their overseas investors. We're also in the aftermath of World War II. So there's a strong interest in encouraging investment flows, strengthening economic relationships, and trying to rebuild the world economic order. So it is in this context that you see states starting to sign bilateral investment treaties. These are essentially treaties in which states reciprocally undertake to promote and protect each other's investments. These treaties set out a number of different standards. So usual typical standards are promises not to expropriate each other's investments without paying adequate compensation, treating them fairly and equitably, not discriminating against the foreign investors. And interestingly, these protections were then made subject to ISDS, so Investor State Dispute Settlement, which is a mechanism whereby natural persons or corporate entities from one state can bring a claim directly against the host state where they've invested. And this is particularly innovative. So before ISDS, let's take the example, let's say there's a German investor and he's investing in Venezuela by building a farm of solar panels. And as soon as he's finished building them, Venezuela expropriates his investment unlawfully without paying any compensation. The German investor tries to go to the local courts, maybe doesn't get a fair trial. So then what does he have to do? He has to go to the German government, lobby the German government to bring a claim on his behalf against Venezuela. The political relationship between Germany and Venezuela might be such that Germany's not really interested in bringing a diplomatic protection claim, a contentious claim against Venezuela over a small-time investor who's lost a few million. So instead, under the BIT, the German-Venezuela BIT, the German investor would have the ability of bringing a claim directly against Venezuela for the treaty breaches. And the idea is that the German investor gets to appoint an arbitrator. The Venezuelan government gets to appoint an arbitrator. These two arbitrators in turn appoint a presiding arbitrator. And the idea is that they will hopefully feel that their arguments are going to be heard, that any ultimate decision is going to be procedurally fair because their arguments will have been listened to. So that's the idea behind it. And it's worth noting that although the name bilateral investment treaties, there are a lot of BITs, there's also multilateral investment treaties. And a very famous example of this is the Energy Charter Treaty. Turning briefly now to FTAs, so free trade agreements, also known as preferential trade agreements, are much broader in scope, right? They're usually agreed between two or more states, containing reciprocal agreements with a view to reducing or eliminating barriers to trade, facilitating economic cooperation. So they're aimed at the economic integration across most sectors. So usually these will cover a broad spectrum of trade-related issues from goods and services, government procurement, regulatory cooperation, IP, sustainable development, and so on. And it will typically also include provisions on investment. So some states choose to include just investment liberalization provisions. These are commitments aimed at securing reciprocal standards of treatment for foreigners wanting to seek entry into another market. So they're aimed to open up new market access and ensure equal treatment for foreign investors looking to enter the market. And then other states might look to include not just investment liberalization provisions, but also investment protection provisions. So essentially, the type of standards of protections that we see in BITs, like non-expropriation without compensation, non-discrimination, fair and equitable treatment, that these kind of standards and the ISDS mechanism is brought into the FTA. Quite interestingly, let's say you have a state that's negotiating an FTA with another state with whom they have a BIT. Maybe, let's say it's an old generation BIT from the 60s. Sometimes what you see happening is that they terminate the old BIT and instead choose to include modernized and updated investment protection provisions in the investment chapter in the new FTA that they're negotiating. So I hope that's a helpful overview of what BITs and FTAs are and how they interplay.
Yes, very much. Thank you, Clara. Kex?
Thank you very much. And thank you to Clara for wonderfully setting out the whole landscape of what BITs are and what FTAs are. And Clara also touched on the point that the investment chapters in FTA or BITs can take different forms, one of which relates to whether or not there is ISDS. So in my part, I think I'm just going to jump on what she says and elaborate a bit on why there is a move towards treaties that do not have ISDS. So in recent years, there has been an issue of the whole legitimacy of ISDS. There are many factors for this. If I were to talk about it all, we would go on to tomorrow. So I'm just going to touch on a few key issues that have arisen recently. So the first is the issue of damages. The highest ever damages awarded was the sum of 50 billion. This was in the case of Yukos in Russia. Everyone's familiar with this. So the fact that an act of the government can give rise to such huge sums, and this is more than what the government could spend a year on its taxpayers to improve the lives of its normal citizens. That is something that has raised the question of, is ISDS fit for purpose? I also would like to give two examples of cases where it's not quite clear whether there should be an award in favor of the investor. So, as Clara mentioned, when BITs and FTAs with expropriation clauses were first designed, it was really clear. It's a clear, the government comes in, you have a solar farm, we take it, we nationalize it, it's now us. It's clear. It's explicit, direct. But over the years, there are clauses such as indirect expropriation, where you could take an act where the investment remains with the investor, but it could be such that you don't give a license, or you impose conditions on the license such that effectively there are no way, effectively the whole investment is diluted. That touches a lot on regulatory powers of the state. And I have two cases to show in this regard. The first is, imagine a case where there is a hotel on the beach, and the hotel wants to expand into the beach, but they can't do so because the government says that, no, there are turtles that actually want to lay eggs on my beach, and I'm taking this act to prevent you from doing so in favor of the turtles. And this is an actual case. The second case is, as I'm sure many of you are familiar with, is the issue of cigarettes. And many countries have passed laws on plain packaging to make sure to protect the health of people who use cigarettes. Some of these cases with regulatory issues have been decided in favor of investors. Others have been decided in favor of states. But there is a growing concern that these kind of cases that don't fall strictly within the original type of direct expropriation raises questions on how the balance between a state's right to regulate ought to interact with other things. And so I'll just end off with one point for this part, that there have been issues against ISDS across the years. Maybe now the issues are more environmental, human rights, health, right to regulate, and even in COVID. But there have been issues, but there have been cases, there have been questions raised about ISDS throughout the years. In 2001, Argentina took steps to regulate its financial crisis, and it was faced with an onslaught of cases. So the issues that raised in ISDS are not new. They may change, but this is where we are currently. Thank you.
Thanks very much, Kex. Very helpful. And to finish off this question, Alejandro, if you could give us a couple thoughts.
Thank you so much. I believe it's been a very comprehensive analysis by Clara and Kex, but I want to just highlight 2 points. The first one is that both FTAs and BITs, as was explained, these are international treaties and they are concluded by states. And as such, you'll see that the scope of the obligation or standards, such as expropriation, as was explained, it's a result of a negotiation by the states themselves. And what I want to explain here is, at the end of the day, ISDS itself, it's a mechanism that it's created by the states, and the scope of each obligation, as well as the consent to arbitrate of the states, are so to say tailored by them. That's one issue that I want to highlight. And the second one, regarding the developments, I want to build upon what was said by Kex. You'll see right now that there's some sort of scrutiny on the reform to ISDS, because you'll see several decisions by tribunals that are not so well received. And therefore, there has been some analysis as to the idea that it's maybe not that a good system, or that it has failed. So I think that's a general point that I want to make. Perhaps we can touch upon this later on the reforms of the ISDS system. But just I wanted to point this and state this. And I also want to mention regarding the developments that you'll see nowadays that we have more FTAs which are multilateral. You'll see in the first instance, as was explained by Clara, you have bilateral BITs and also FTAs, but nowadays you have multilateral treaties such as CPTPP with more than 10 countries, and also you have mega treaties such as the African Continental Free Trade Area, which is almost all Africa. So what I want to point here is we're having more treaties that are bigger in scope, so to say, or more countries are signing up to those treaties. And I think that's all I want to point out here.
Thank you very much. Very helpful overview. I could have used you all when I was in law school, learning this stuff for the first time. So thank you very much.
So our next question is, what factors do states take into account and prioritize when negotiating and drafting BITs and FTAs, and how do states navigate the balance between protecting investors and preserving regulatory space for public policy objectives? Mark, grateful for your thoughts.
Thank you, Sunita, and thank you for putting this webinar together. And good morning, good afternoon, and good evening to everyone. And I would say that the classic view is that capital exporting states, as a general matter, seek to maximize the protections for their outbound investments, for the investments of their investors in the states, in other countries, particularly developing countries. And they seek to ensure that they have substantive protections, so they're not stuck going to the local courts, which sometimes are ineffective, and that they have access to justice, so that they don't have to seek the diplomatic representation of their state, right, which gets complicated. And then from the capital importing state's perspective, they seek to attract foreign direct investment, particularly into certain sectors, and certain industries, promote technology transfers and so forth. So they want to maximize investment in their economy, but they also want to maintain as much regulatory freedom as possible, right? And we've seen, as was mentioned already by Kexian and Alejandro, that some of these investment treaty cases have given rise to controversial disputes over investors who seek to challenge certain core policy issues and regulations, particularly in the area of environment, public safety, public health, and so forth, labor standards and whatnot. And so capital importing states are stuck with having to try to balance these competing concerns. That, I say, was the classic view. It still holds some merit, still holds some truth, I would say. The picture has just become a little more complicated over the past quarter century, since investment treaty cases have become more widespread. And I would say that you have capital exporting countries now that have been the subject, have been respondents in many of these cases, and I would say have developed a new appreciation for this need to balance different rights. That was certainly the story of the United States under the NAFTA. It was originally a bilateral agreement between the US and Mexico, was trilateralized to include Canada, and then that set off a flood of investment treaty cases between Canadian investors and the US and vice versa. And this gave the US and Canada a new appreciation for what it looks like to be on the receiving end of these claims. And then you saw the 2012 model BIT and the new generation of US BITs and investment chapters and free trade agreements that were much more balanced, right? Along the lines of some of the things we've already talked about. The substantive protections, procedural mechanisms, and so forth. So I think you've seen this need to balance regulatory space against investor protections, not just among north-south, capital exporting, capital importing, but among advanced industrialized countries as well. Spain is one example, has been sued now over 50 times, mostly for regulatory changes in its renewable energy space. And I think this has created a fundamental shift. And so if you look at the CETA, right, the Comprehensive Economic and Trade Agreement between Canada and the EU, which hasn't come into force, but is provisionally applicable today, you see a much more nuanced balancing, both procedurally and substantively, between mostly capital exporting states. You also see that in the USMCA, which replaced the NAFTA, and in other agreements. The final point is, and I don't think you can ever entirely lose sight of this, is that you always have political and diplomatic relations that lurk behind these treaties. And so when a new treaty is being drafted, you ask yourself, you know, what are the true goals, the diplomatic goals, the economic goals, the political goals of the states involved? So, you know, for example, the US now is interested in, just by one example, looking at Central Asia and securing certain access to resources for US companies. And so you see, you know, a gradual evolution in what types of treaties are being signed and what the content of those treaties are. China is another good example, which has had a fundamental change in its policy of BITs, which again follows its different priorities in terms of its economic expansion around the globe. So I'll leave off there. Thank you.
Thank you. That was very insightful indeed. Sudhanshu?
So I was just saying thank you for having me, and you know, it is indeed a pleasure to be here. In response to the specific question, I think Mark has touched on the main points. So I'm going to try to say something different, and that is, I think even before you talk about what factors do state take into account when negotiating investment treaties, I think most states, especially in the current geopolitical environment, I think going back to the past decade, the first question for every state is whether there should be, you know, whether the state should have a BIT or an FTA. I think that's an overarching question that most states grapple with, because the era of states signing bilateral investment treaties in a wholesale manner is over. You know, states no longer sign investment treaties as photo opportunities or part of a broader diplomatic exercise with their trade and political allies. It's a very carefully considered decision in my experience, especially working with so many states. As a practitioner over the last decade, states do not easily undertake obligations under international law. It is a very serious matter. It should have always been a serious matter, but for some reason, you know, you had this trend, especially in the 80s and 90s, where hundreds of BITs were signed. But I think things have changed. States have become more sophisticated. Investors were sophisticated, but they have become even more sophisticated. So the whole, I think the dynamic between states and investors has changed. So I think states will consider very carefully whether to sign a BIT, and if to sign a BIT, what is the right partner, what is the right country that they would undertake negotiations with. So that's also a very factor. I mean, it is still politics and underlying geopolitical factors still play a factor in all of this, selecting the right partner. I'm not going to deny that. But what I'm saying is that the negotiation exercise itself is more carefully considered from the state's perspective. Now, once you decide to sign a BIT, which is not an easy decision in itself, I think the factors are, you know, what Mark outlined, which is for developing states, it's always about protecting their defensive interests, protecting their regulatory space. And for developed states, it's more about having robust investment protection for their outbound investments. That being said, I think another factor that is very important when you're negotiating an investment treaty is whether to have ISDS or not, because of all the criticisms that I think you've already heard from my fellow panelists about investment treaties in general and investor-state dispute settlement in particular. So states, despite having BITs, are more cautious about including investor-state dispute settlement mechanisms. There are many states, such as Brazil, which have investment treaties but do not have investor-state dispute settlement provisions in those treaties. So states weigh the benefits of providing investors with recourse, and they weigh that risk against the benefit against the risk of exposing themselves to these costly investment arbitration claims, which can run into just the cost of defending them can run into tens of millions of dollars, not taking into account the damages awards that may result from these treaties. I think one of the panelists mentioned a 50 billion award. That's like the highest, but even $1 billion award can be a lot for some of the developing states. So I think negotiating investment treaties in general is a very carefully considered exercise, and then having ISDS in those treaties is again very, very carefully considered. And I think there was a second part to your question, which is about the regulatory space. And I think Mark also provided his views, which I generally agree. And mostly this is done, protecting regulatory state is mostly done, protecting regulatory space, is mostly done through having carefully drafted treaty language. And that, I would say, starts with the preamble. I think somebody mentioned, another panelist mentioned, I think it was Kex, who mentioned these tobacco cases, right, where the states' plain packaging laws were challenged. Plain packaging laws for cigarettes were challenged under investment treaties. And I think I worked on one of those cases against the state of Uruguay. This was a long time ago, but the case turned on, for example, the way the preamble was drafted, right? And whether the preamble afforded enough protection and enough regulatory space for the right of the state to regulate in public interest. So although that specific treaty was obviously not drafted keeping this particular case in mind about plain packaging cigarette laws, but there was enough leeway in the way the preamble was drafted that the tribunal interpreted it in a way to safeguard the state's right to regulate. And there are other various ways which I'm sure we can talk about, and probably there's not enough time, which is exclusions and carve-outs and non-precluded measures, and some treaties, modern treaties, have provisions on investor obligations, corporate social responsibility, and so on and so forth. So I think I would leave it at that for now.
Thank you, Sudhanshu. That was really interesting. Kex?
Thanks very much, Sunita. And I have such a Herculean task of trying to say something after my wonderful panelists, Mark and Sudhanshu, have actually comprehensively outlined almost everything that I wanted to say on this. So I thought maybe I will just elaborate a bit about the right to regulate and how states balance that. And it was amiss of me not to disclose this right at the start, but whatever I say in this talk is made in my own personal capacity and does not reflect the views of the Singapore government. So in terms of the right to regulate, I think one thing that we are all seized with the fact that states all do want to regulate, and they are now trying to see how to put it into their different treaties. So there's different ways. As Sudhanshu said in his case, it was put in a preamble. We have seen others where they have incorporated the exceptions of the General Agreement of Trade and Tariffs, the WTO agreement, and they have incorporated it wholesale into the investment chapter. So that's another way. And there are also other approaches where within the text of a provision itself, you set out the exceptions. So one of the most famous examples would be for indirect expropriation. There is a defense if you regulate, if you take the police powers doctrine, and there are specific conditions that you have to fulfill in order to avail yourself of the defense. What I also wanted to draw attention to is the fact that we think of right to regulate as this homogeneous right of the state, and that all states do want to regulate in their public policy. Whereas I think on the ground, the difficulty it is more nuanced than that. So I say this because not all states have the same public policy objectives. Some states do, even between different public policy objectives, there are competing tensions, between health, environment, human rights, local indigenous populations, arts and cultures. These are a few examples of public policy exceptions that have arisen, but it doesn't mean that every state pays the same emphasis on each of this. So different states to an FTA or a BIP might have different priorities, and then it would be for the different states to agree as to where the direct balance would be. And with that, I think we have wrapped up this topic, and I'll hand it back to Gianni or Sunitha.
Thank you, Kex.
Thanks very much, everyone. So taking a look kind of like what happens on the ground. So in practice, when doing these transactions, there's often a commercial contract negotiated between the investor and the host state with respect to the individual project. So in your experience, how do the rights under these commercial contracts interact with the rights available under the relevant BIT or FTA? Sudhanshu, if you could kick us off with that question.
Thank you, Gianni. That's, again, a very relevant question, especially for us as practitioners who practice investment arbitration, because this is an issue that almost inevitably comes up in every case, because although the treaty in question, the BIT or the FTA, is signed by the host state, that is the sovereign state under, which is recognized under international law, the conduct in question that is alleged to breach the treaty involves a multitude of organs that go beyond the state in question. So that's why I said it's a very relevant question, because it arises in almost every case. Now, your question also said that how do these commercial contracts negotiated between the investor and the host state interact with BITs? But in almost every case that I have seen, at least, the state itself is not a party to the contract, right? The party to the contract is a state organ, which could be a state-owned entity, which is like a government company. In many cases, it is also a subnational government, especially in federal systems like the United States or India, where I'm originally from, or other federal jurisdictions. And it could also be like a local government. So the contract itself is signed by not the host state, but an organ. And the obligations in question obviously interact with the obligations of the state under the BIT. And that is because under public international law, the status of a state organ, according to the state's internal law, is not relevant for the purpose of state responsibility. In other words, it does not matter whether the organ is a state-owned company or a subnational government or the state itself, or even the judicial organs of a state, right? I mean, in all of these denial of justice cases, we see that the conduct that is alleged to breach of the BIT is a court. So it does not matter what organ it is. The consequence for the state is that the conduct of any of these organs can lead to a breach of the BIT. And so in that sense, commercial contracts, which are entered into by state organs, internationalize private agreements into these international law obligations under BITs, and can serve as a back channel for bringing investment disputes against the state. Now, I know there are these questions on the substance about what type of conduct can give rise to a BIT and all of that, but I think before I get into that, I think one of the most important issues that arises from a practical perspective is about this awareness of these state organs of the state's international obligations, because these, especially, and I'm especially talking about maybe not the capital exporting countries, but more so the capital importing countries, because these state organs that operate at a subnational or a local level often lack awareness of these BITs, and this gap in understanding can, and frequently actually in my experience does, lead to conduct that can unintentionally trigger investment disputes. So for example, a subnational regulator might revoke a license, a mining license, or impose, let's say, new conditions on that license on a foreign investor, completely unaware that such action could breach a state's international obligations under a BIT. And this has given rise to many, many investment disputes. If you go back and look at, some of these cases which have arisen in the recent years. There is also the issue of attribution when you're talking about interaction between private commercial contracts, private commercial conduct under a contract, and a state's obligations, because ordinary commercial conduct that is not in exercise of governmental authority cannot ordinarily be attributed to the state for the purpose of state responsibility. So in almost every case, the question is whether the state organ in question was acting in a governmental capacity, whether there was enough governmental supervision and control so that its act can be attributed to the state itself. So that is a relevant question. And when you come to, so once you overcome these issues, once you overcome these underlying issues, in terms of substance, as I was going to say very briefly, the key issue is whether an investor who's bringing the claim against the state for breach of contract, whether the investor can elevate that breach into a treaty claim. And tribunals almost always look at whether the state organ was, as I was saying, acting in a sovereign capacity. But now the question is different. It's not a question of attribution. It's a question of liability. It's a question on the merits, whether the state organ was acting in a sovereign capacity or whether it was acting in a commercial capacity, because most tribunals have taken the view that if the conduct is purely commercial, if the conduct is purely undertaken as a contractual party to the private, in respect of the private agreement, then that conduct per se cannot be elevated to the level of a treaty breach. And then the next question is whether, if the conduct was something more than commercial and was in a sovereign capacity, whether the breach that results from that conduct meets the standards under the BITs. So that is the question on the substance. Very quickly, another issue is the question of umbrella clauses. I'm sure some of you at least are familiar with what umbrella clauses are, but umbrella clauses are provisions in BITs which elevate contractual obligations into treaty obligations. They go something like, most often they go something like, each party shall observe any obligation it may have entered in with regard to their investments, and which means that any obligation could include any obligation undertaken with respect to a contract. So if there is an umbrella clause in a BIT, then that automatically elevates a pure contractual breach into a BIT violation. Umbrella clauses are not so common, I would say, in modern BITs. They were more of a residue or representative of the era in which states signed a lot of BITs. I think in the modern era, where states carefully consider their obligations and the treaty language, it is not so common to have umbrella clauses, but in case there are, then that can have practical implications into how commercial obligations under private contracts and treaty obligations interact. So I think I'm going to leave it there. There are many other issues that we could probably discuss, but there's not enough time. Thank you.
Thanks very much, Sudhanshu. Alejandro?
Thank you. I mean, following up on Sudhanshu's explanation, you'll see that you have two different types of rights. The one that's that arises from the contract, and the other one from the BIT or FTA. And as Sudhanshu explained, you have issues on parallel claims and umbrella clauses, but also you have the possibility of having fork in the road provisions, where normally it is a provision in which you have to choose either national courts or the international mechanism. But also you'll see in some cases in which the fork in the road is so broad that it could encompass also commercial arbitration. And also regarding this type of clauses, you can also have waivers in which, again, the waiver is so broad that it can also include contractual claims, and therefore you do have a way to mitigate parallel claims. And finally, I guess the last point that I want to raise here is another interaction that I see. You'll see in some FTAs and BITs that in the very definition of investment, you can see a contract itself. And not all type of contracts, of course, but for instance, you have in USMCA in the definition of investment in Article 14.1 that turnkey contracts, construction contracts, management, production contracts, or concessions can be seen as investments. And also, again, in USMCA, you have a specific annex where if you have a contract with the government in certain sectors, you have access to full ISDS. So just to mention that, of course, there's different type of interactions regarding mainly the, so to say, procedural aspect, but also in substance. So the very, let's say the very first step, the definition of investment, you'll see that most oftentimes your contract can be an investment, but of course you have to check the definition of investment in that precise FTA or BIT. And I think I'll leave it with that.
Thank you very much. Appreciate your thoughts, both of you. So our next question is turning kind of to the procedural reform stage. So what procedural reforms have you seen, or at least do you anticipate seeing for the future of ISDS? Kex, if you could take that one first.
Thanks very much, Kiani. So on procedural reforms, I think one of the major forums that discusses this issue is Ancestral Working Group 3, and it's specifically tasked to discuss all issues relating to procedural reform for ISDS. So there are multiple procedural reforms that have been discussed and are being discussed in parallel. And I just wanted to focus on two. The first would be the issue of procedural rules itself. So to set the context, procedural rules itself do not ensure the correctness of the award. It's not a substantive thing. So ultimately, you don't change the underlying treaty provisions. But what it does is that it helps weave out frivolous claims. So if you have disclosure of third-party funding, if you are required to put up security for cost for a frivolous claim, that would also discourage frivolous claims from being filed. There are also others, such as cost to follow the event, which is a principle in domestic litigation that the loser pays. There's also stricter timelines, so to make sure that the proceedings do not drag on too long and that they do need to conclude within within a reasonable period of time. The other big bucket of issues that is yet to take fruit, which I would consider the structural reform. So this is an initiative that has been proposed by the EU, which is to set up a multilateral investment court or an appellate court. So what it does is that in the current ISDS system, as Clara mentioned in her introductory remarks, each party chooses one arbitrator and then they appoint a lead presiding arbitrator. But what this happens is that there could be biases, and by the fact that you choose your own arbitrator shows that generally investors tend to choose arbitrators who favor their positions, same as respondent states. So what this does is that the whole idea of the court is that you choose judges who are familiar with public policy, and it's a randomized way to assign judges to the case, which then ensures the correctness and the standard for which investment decisions will be judged moving forward. And just to end off, whilst a lot of the talk is on Ancestral Working Group 3, there are also other procedural rules reform that are being discussed. So ICSID's own rules were discussed and updated as of 2022. And in parallel, other states, when they are negotiating their treaties or seeking to update them, they also do update their procedural rules in these treaties.
Thank you very much. Alejandro?
Sure. I mean, I do see some other points that have changed regarding the procedural aspects. The first one is transparency. You'll see in the most recent discussions, there's been really a forum on on rules on transparency. And you also see that in certain specific FTAs, you have transparency provisions, such as USMCA and CPTPP. You have more ways to, so to say, to publicly make available certain documents. And also there's been some discussions on code of conducts. You'll see the 2024 discussion by UNCITRAL and ICSID on code of conduct, because there was, in a way, a lack of information regarding repeated appointments and lack of independence. And the last point that I want to raise is the mechanism itself. You again see in the USMCA an annex which is normally seen as an skinny ISDS, where you are reducing the scope of ISDS to a certain specific provisions. Just in there you can only raise a violation to MFN or national treatment or direct expropriation, but not to all of the obligations in the FTA. And I think I'll leave it with that.
Thanks very much. Clara?
Sure. I'll just briefly add the same caveat that Kex added early on, that these are views that I express in my personal capacity and are not necessarily the views of the UK government. But speaking on reforms, Kex and Alejandro both highlighted some fascinating reforms being discussed at the moment. I thought I'd add another one to the list. This is being discussed at Onstral Working Group 3, and it's the Advisory Center. So this would be an advisory center on international investment dispute resolution. It's modeled after the WTO Advisory Center that was established back in 2001. The idea is that this would be an intergovernmental institution that can provide technical assistance, capacity building, legal services, especially for least developing countries and developing countries, and can also provide legal services to defend in ISDS disputes. So actually, negotiations on the statute of the Advisory Center concluded in principle last summer, so in July 2024. And now the focus of the conversation has shifted to operationalizing the Advisory Center by looking at things such as cost of membership, methods of payment, location of headquarters, criteria for prioritizing access to these services. And also, interestingly, as part of the conversation is, how do you then implement this reform? How do you give effect to it? And I think that's also feeds into the other Onstral Working Group 3 reforms that Kex mentioned. There's really interesting legal questions on how do you implement these? Are they annexes to Onstral arbitration rules? Are they model provisions? Are they going to be a multilateral treaty that gives effect to these reforms on a bilateral basis, so that by signing up to a multilateral treaty, you can thereby affect your own bilateral relationships? So really interesting questions there.
Thanks very much, everyone.
Turning now to substantive reforms. What substantive reforms have you seen or anticipate seeing for the future of ISDS? We'll start with Mark. Grateful for your thoughts.
Thank you, Sunita. Mindful of time, I'll cover this very quickly. I think the reforms are mostly what Sudhanshu characterized as much more careful treaty negotiation these days, because just about every state has some experience with investor-state arbitration, and they now see some of the dangers or some of the pitfalls, I think, more clearly, and there's much more attention paid to a lot of the substantive standards in treaties, starting with FET, which, and in particular, legitimate expectations, which is sometimes considered a subspecies of fair and equitable treatment. It accounts for the overwhelming number of successful claims against states. It accounts for most of the more controversial decisions. and it's not defined in many early generation treaties. And so a lot of focus has been placed there in terms of how do you cabinet a bit more, how do you define it to draw this balance. You also have explicit right to regulate provisions in a lot of treaties. The CETA between Canada and the EU that I mentioned before has a provision in Article 8.9, and I'll just paraphrase. It says, the mere fact that a party regulates in a manner which negatively affects an investment or interferes with investors' expectations does not constitute a breach of this treaty chapter. So you have an explicit reference to legitimate expectations, and the mere fact that an investment has been harmed by regulation is a fact of life, and it doesn't necessarily give rise to a treaty breach. Sudhanshu also mentioned briefly, social responsibility, corporate responsibility obligations, which you now see creeping into some treaties. And it's something that puts some of the obligations on the side of the investor. The Morocco and Nigeria BIT, which was signed in 2016, is a good example of that. And it has some innovative provisions requiring the investors to conduct environmental and social impact assessments to meet certain corporate social responsibility standards, to contribute to sustainable development, and so forth. And I think you're starting to see a bit of a rebalancing of the treaties by imposing certain threshold obligations on the investors to begin with. You also see in that regard some climate change considerations which are coming into treaties. The UK-New Zealand FTA from 2022 is an interesting example of that, which refers to measures taken to mitigate climate change, which are given some, additional protection and are less susceptible to being a regulation that triggers treaty protections. So those are just some examples of the substantive standards. I'd say expropriation as well. You now have in a number of treaties an annex, which plays with the standards that is required to constitute a regulatory expropriation or an indirect expropriation, right? So instead of a substantive deprivation, you now see some language that says radical deprivation, right? Which is required in order to constitute an expropriation. So those are just some examples of some of the substantive changes that you see coming into treaties, again, to affect this rebalancing and protecting states' rights to regulate that we've discussed now. Thank you.
Thank you, Mark. Clara?
Sure. So I thought to complement Mark's very interesting remarks, I'd maybe give an overview of the discussions that are happening at the OECD. So the OECD has a work stream on, yeah, you can hear me, great. The OECD has a work stream on the future of investment treaties. And so compared to UNCITRAL Working Group 3, which is looking more at procedural reforms, the OECD is looking at substantive reforms. So there's two tracks. Track one is basically exploring the intersection between the Paris Agreement and investment treaties. And one aspect of this has been exploring ways of eliminating or reducing investment treaty benefits of high carbon activities such as fossil fuels. So the OECD Secretariat prepared a paper setting out a number of different options, including fossil fuel carve-out options. And this is a publicly published paper in case you're interested. Another aspect of this work stream has looked at how can investment agreements be used to more actively support climate-aligned investments, for example, through better market access or through investment facilitation. In other words, looking at how investment treaties can be used to promote climate-friendly investments. And here, an interesting example, a very recent one, if you're interested, is the Agreement on Climate Change, Trade, and Sustainability. It was signed in November last year between Costa Rica, Iceland, New Zealand, and Switzerland. And the idea is to remove trade restrictions on, I think, more than 100 environmental services, eliminating fossil fuel subsidies. So again, trying to improve market access for climate-friendly investments. Track 2 of the OECD workstream looks at how to modernize substantive provisions in old BIT. So I guess the premise here is there's roughly 2,000 investment treaties currently in force that were concluded many decades ago under different economic circumstances and with different objectives, as panelists have mentioned throughout this webinar. And I guess in the older generation treaties, there was perhaps more a focus on encouraging investment. And so these standards are phrased rather broadly in open-ended manners, and they didn't contain as many explicit references to some of the regulatory aims that Kex mentioned, such as consumer protection, climate, health. And so you see a lot of states now looking at modernizing these provisions. And the premise then of this workstream at OECD is, well, renegotiating all these bilateral treaties is very cost and time consuming. And so the premise is are states interested in potentially signing up to a single multilateral treaty through which they can then amend all of their bilateral relationships? The challenge here, though, is that you have to reach agreement on what the new standards should look like. So at these sessions, they choose provisions, let's take FET or EXPRO and MFN, and try and explore whether there's consensus around the, I think, 100 plus jurisdictions that participate on the contours and defining what a modern FET clause, for example, should look like. So that's a high-level overview of the discussions taking place at OECD.
Thank you, Clara, for that overview.
Thanks, everyone. So next question, and yes, I realize we're running relatively short on time, so I'll try and be quick with this question. But what role do investment treaties play on investors' decision to invest in a country? And have you seen any changes to this awareness throughout your career? Mark, if you could take that one.
Thank you, Johnny. I would say that a couple decades ago, the awareness of investors of the investment treaty protections was very low. It was rare to find a general counsel at a major corporation, even one that was investing long-term, making large long-term investments, such as in hydrocarbons or LNG plant or something which is going to live, or mining operations going to live in the country for decades and be subject to changing regimes and so forth. The awareness tended to be low. Today, that has changed quite significantly. I would say that the many law firms that are involved in investor-state arbitration, they speak with their clients all the time about this. So the awareness, I think, is much higher. Not 100%. Sometimes there are surprises, but it's much higher these days. That said, I don't think I've ever seen myself the situation where an investor has said, I won't invest in a particular jurisdiction because there's no investment treaty protections, or the protections are, there's a treaty, but the protections are insufficient. Usually, in my experience, there are other overarching factors, such as the fact that the lithium is located in Serbia, not somewhere else, or the tax regime, or the ability to export from that state. And some of these more fundamental investment-related decisions are driving that overall decision. But what I do see is investors much more willing to do an analysis of what their treaty protections are, sometimes prompted by their outside counsel. There's sort of a cottage industry, I would say now, in advising clients on their investment treaty protections, and perhaps reorganizing the holding structure before a dispute arises, so that they may take advantage of maybe better tax regime, but also at the same time investment protections. And I think that's something that you see much more frequently these days than you did in past years.
Thanks, Mark. Sudhanshu?
Yeah, no, thank you, Mark. I think that was very comprehensive, and I'm also very cognizant of the time. So, I mean, I completely agree that the awareness has grown, and I would just add that the awareness has grown not just in the capital exporting world, which were the leading drivers of investment treaties traditionally, But I think the awareness has also grown all across the world. So even in the capital importing, so-called capital importing a part of the world, there are, I mean, it's no longer like black and white. It's no longer strictly capital importing countries. Capital importing countries can also have outbound investments that they may want to protect. So I think awareness has grown even in that, and certainly corporations are more aware of it. I agree with Mark that having investment treaties is not the sole determinative factor of whether to invest in a country, but I think when you're investing, certainly your investment advisors and legal counsel would advise you to have some sort of protection that goes beyond what is available under the domestic law of the host state. And I think that's where investment treaties come into play. I mean, investors also structure, often, especially in certain sectors, I would say investments, especially in sectors, where there is a lot of capital involved and where there's a lot of money moving into various jurisdictions. Investors structure their investments through countries that provide treaty protection. Now that you can call that treaty shopping, or you can call that careful structuring of the investment. I mean, that could also give rise to potential jurisdictional issues in actual investment disputes, but in the real world, structuring does take place. And I think governments on their part are also very conscious of this awareness on the part of investors, and they're very cautious about negotiating BITs which exclude protection to investors which engage in treaty shopping, especially for example where treaty shopping occurs after a dispute has arisen. So I think that can give rise to arguments regarding whether the structuring was done in good faith or bad faith. So I think these are some of the careful questions that states and investors consider, especially in recent years.
Thanks very much, both. So kind of looking slightly at the flip side of that, right? So there's the investors' incentives. Do they know about this? What are they getting out of it? Kind of on the other side, how do states benefit from these treaties? Alejandro?
Thank you, Gianni. I should have said this before, but also I want to do the same caveat. I'm speaking on my personal behalf, not on behalf of the Mexican government. And I think this is a very interesting question. And you'll see that the main point here is the promotion of investments. But you'll see statements from commentators that really cut both ways, in the sense that you'll see some articles saying that these type of treaties are little to no help in promoting investments. And you'll see others which demonstrate that there is indeed certain data that could support that the treaty indeed foster the investment. So I believe this is an analysis that should be done in a case-by-case basis, but it could be really that for certain countries, certain specific FTAs or BITs did foster, and in general for others, it didn't. And I remember Sudhanshu just mentioned some minutes ago the example of Brazil. You see, Brazil is like top 20 in as a destination of foreign direct investment, and as he said, they do not have ISDS in their BITs. So is it really a consequence of ISDS having more investment? That's something, again, that should be analyzed in a case-by-case basis. And the other point that I see normally in this type of comments is by having this net of FTAs and BITs, you show, or at least the countries, the states show a certain degree of complying with the rule of law. And that also can be seen specifically when there's an adverse award and when that award is paid. And again, this degree of complying with the rule of law is not only towards investors, but also with other states.
Thanks very much, Alejandro.
Our next question is, how has your experience in government contributed to your ability to practice investment arbitration? Mark?
Thanks, Anita. I'll be super quick. I would say that I have an appreciation of how complex it is for a state to defend these claims, both in terms of organizing your different agencies, perhaps creating an interagency group, which agency is going to be the lead agency to decide what the positions are that the state is going to take, to be responsible for gathering documents or other information, finding witnesses, and bringing them to the arbitration, even funding the case. Many states simply have their regular procurement laws, and you have to put out for a tender just to hire an expert or outside counsel. It's much more complex. Whereas the investor, they want money. They want compensation for their investment, and they want to maximize their returns on their investment claims. So it's a much simpler goal. It used to be said that investor-state arbitration was rigged in favor of claimants, and there were too many decisions in favor of claimants. I don't think that's the case anymore. I think that a lot of states, whether they do the defense purely in-house, like some do, or they do a combination with outside counsel or entirely outside counsel, have gotten much, much better at defending these claims. And you see that in the statistics, the number of cases that are dismissed for jurisdictional at the jurisdictional phase, or that succeed on the merits, or perhaps that there is a finding of breach, but the damage is very, very low. I think you see that more often. You see states becoming much stated about defending these claims. Thank you.
Thank you, Mark. Sudhanshu?
Yeah, I mean, I'm going to agree mostly with what Mark said. I mean, it just makes you more aware and empathetic and, understanding of the state's policy objectives and defensive concerns in investment arbitrations. And but I mean, it doesn't matter on which side you are, whether you're on the side of as a practitioner, whether you're on the side of the state or whether you're on the side of the investor. I mean, it just makes you aware of how deeply challenging it is for the state to be, firstly giving away commitments, undertaking significant commitments under international law, and then engaging in this complex dispute settlement before an international forum, bypassing its domestic body. So it's not easy for states it's not likely that states undertake these obligations. I mean, from a practical perspective, I think Mark briefly touched on this, but this interagency coordination is a very important thing. And because, I've worked in the government, I mean, I just know how it works, how complex bureaucracies can be, especially in certain countries, which I'm not going to name, but, obviously it varies from country to country, but some countries can be really complicated, and it's very important that you know how things work, especially in terms of bureaucracies and interagency coordination, because once you get into an arbitration, it's not just about defending the state, it's not just about these standards that we talk about, but, the practical challenges are collection of evidence, selection of witnesses, document production, and so on and so forth. So if you know where to look and who to talk to in the state, and what are the right points to touch upon, I think it becomes a little easier, although navigating these complex bureaucracies and communicating effectively with different stakeholders within a large state can be a challenge, but it just makes it a little easier if you know how things work internally. So I think I'm just going to leave it there.
Thank you, Sudhanshu.
Thank you very much, everyone. Really appreciate all the insight. I think we have time for at least one question. So let's see. Okay. This is kind of a question on terminology, I think, kind of making sure we're all, because there's a lot of terms we all used, and I know, at least for me, when I was working with these issues, it just takes a while to get used to everything. And people use things interchangeably. So I think this is a helpful question for everyone. With regard to the differences between investment treaties and FTAs, in the case of the Canada, US, Mexico agreement, should we think of it as a multilateral investment treaty or as a free trade agreement? And is this distinction important in terms of defining legal protections, like from a dispute resolution perspective, or just within the broader context of foreign investment? I guess it's for anyone. So if any of the panelists are keen to answer that one, please jump in.
Sure. I mean, I can answer that question. I'll go back to the explanation by Clara. So you have two different types of treaties, the BIT and the FTA. The BIT is related only to investments, and the FTA is much broader treaty that encompasses different type of disciplines, such as, I don't know, TBT, SPS, investment as well. But the answer to that question is the USMCA is an FTA because it's not only regarding investment protection. And the second question was that, well, is there any difference as to having an FTA or BAT? I think that the relevant part here is the analysis per se of the obligations, and not really where do you put that specific treaty. I mean, the name of the treaty is not really important, but you should take into consideration the obligations themselves. And you'll see most of them are similar to the ones we have in a BIT. But again, I would just suggest to have an analysis of the treaty itself.
I mean, to briefly follow on, fully agree, Alejandro. I think one thing which is interesting is that if you have a bilateral investment treaty, it's just investment provisions. And I guess all relevant provisions are going to be in that treaty text. And compare that with an FTA, where often it's a chapter or within a chapter within a broader FTA. And the broader FTA can have even 30 chapters on all sorts of different issues. And there's usually also introductory chapters and final chapters, and there's general exceptions that apply across the entire treaty. So what's interesting, for example, you're in a context of an FTA with an investment chapter, is you will have to read the investment chapter, but you will also have to read other provisions that might be applicable. So for example, you might have general exceptions at the end of the FTA and the final provisions chapter that apply, or in the general exceptions, if there's a specific general exceptions chapter, that apply across the entire agreement, across only some chapters. And so it's, when you're examining an FTA and an investment chapter in an FTA, you have to be aware of the broader context as well, as there might be other provisions that might also be relevant to your interpretation of the investment chapter. But then again, it really depends on the treaty, because some FTAs will completely close off the investment chapter and try and make it as much as possible its own universe, like a BIT would be. And then you have other FTAs that might have more interactions. But that's one point that is worth bearing in mind.
Thanks very much, both. I think, Clara, to your actually to both your points, one thing that I found interesting was you look at, you know, an FTA or some of these larger agreements, sometimes there are hundreds of pages, different chapters, all these things, and you get a BIT in front of you, and it's like so much shorter. And people are like, wait a minute, where's the rest of it? But it's interesting because of the way the chapters work and everything interacts. So yeah, definitely something to think about when you're actually looking at these things. So I think that's all the time we have for questions. Thank you for everyone who asked the questions. Sorry we couldn't get to all of them. And from my end, thank you to all the panelists, and I'll have Sunita close us out.
Thank you very much to our stellar panelists for their valuable time and insights, as well as to my expert co-moderator for his excellent steering of the discussion. A special thank you also to our technology sponsor, Maxwell Chambers, and to everyone for joining us today. We hope to see you at a future VYAP event.